Hello everyone, welcome to the Street Crime UK YouTube channel. Thank you for joining us. Please don't forget to like, share and subscribe for more exciting true crime content. Today we look at a former rave organiser who was dubbed the king of acid house in the 80s, who later turned to fraud and building this bizarre contraption to help him access victims' bank accounts. Tony Muldowney Colston was behind some of Britain's most infamous all-night raves 3 decades ago, before the scene was shut down due to rampant drug use. The self-styled anarcho-capitalist who uses the surname Colston Hater then became a cyber fraudster, masterminding a £1.25 million cyber bank heist, which saw him jailed for 5.5 years in 2014. But after his release from prison, the now 53-year-old soon returned to con artistry. This creating a bizarre machine from a card reader and voice-altering equipment. Detectives were astonished by the wacky-looking construction when they raided a property linked to the fraudster, and were even more surprised to discover that it actually worked. Mr. Colston used the machine as part of a plot which saw him access £500,000 in victims' bank accounts, and for which he was packed off back to jail. In his previous con, for which he was jailed in 2014, Mr. Colston led a gang who planted a high-tech computer hacking device into a bank to empty high-value accounts. They used a keyboard video mouse or KVM device, which cost as little as £10 and is popular with suspicious partners looking to catch their cheating spouses. They used it to take control of multiple computer systems and transmit information remotely. 6 high-worth accounts were emptied, with the University of Portsmouth and the London Metropolitan University among the victims. After his release, Mr. Colston was soon back to his old ways, but this time with his homemade machine. It was used to contact victims and convince them that he was a member of the staff at the bank. Amazingly, experts from the Met's Digital Communication and Cyber Laboratory confirmed the device actually worked. Officers also seized a hard drive containing details of passports and identity cards, 32 credit cards, and a spreadsheet containing names, addresses, email addresses and phone numbers. Detective Inspector Philip McClerney from the Met Police Cybercrime Unit, or MPCCU, said the scam carried out by Mr. Colston affected hundreds of people across the UK and had the potential to affect many more. He is an audacious criminal who only recently was released from prison for carrying out very similar offences. He shows no concern for the welfare of any individual or organisation and has made it clear that he will use a range of methods to achieve significant financial gain for himself. Mr. Colston was once a successful professional gambler and astounded teachers by passing a special O-level event in a fruit machine technology aged just 16. He once raked in £23,000 a day before he was banned from every casino in Britain. Mr. Colston travelled to Hong Kong in 2003 where he set up an engineering company which produced a component for a Formula 1 car. But when he moved back to Britain to marry and start a young family, police believe he became an accomplished fraudster. Police say the weird-looking device was used to alter Mr. Colston's voice to match the age and gender of a genuine customer when he contacted the banks. It also had the capability of playing pre-recorded bank messages. Mr. Colston told detectives that he created the machine to gain access to genuine customer accounts and spirit away cash. Scotland Yard's Digital Communications and Cyber Laboratory confirmed that the machine did what Mr. Colston said it did. Incredibly, Mr. Colston used a similar system to fox police during his rave organising days. Rave goers would ring a phone number, at which point a recorded message on an answering machine would give them random locations around the M25. It would then be updated to reveal the final venue. What do you think about Mr. Colston's device and the time he spent in prison?
Thanks for joining us today. If you enjoyed the video, don't forget to give it a like and a share, and leave any thoughts or suggestions you have in the comments section. We love to read through them all. And if you're new but enjoy UK true crime content, then subscribe to see when our newest video releases. And as always, stay safe.
Hello and welcome to the Street Crime UK YouTube channel. Please don't forget to like, share, comment and subscribe. Today we take a look at the case of Carl Dobson, who's a famous grime MC also known as Crazy Titch. Carl Dobson was born on the 31st of January 1983. He is better known as his stage name Crazy Titch. He is a British grime MC who is now serving a life sentence for murder. Crazy Titch was a successful and well-known grime MC during his active period of MCing. Mr. Dobson was born in Plaistow, East London. As a teenager, Mr. Dobson spent 5 years in Feltham Young Offenders Institute for robbery, handling stolen goods, theft, burglary and criminal damage. Upon his release from prison in 2003, Mr. Dobson turned his attention to grime music, a culture which was steadily growing in the UK music industry. Mr. Dobson had become estranged from his brother Dirty Goods during his childhood, but they had later reconnected and became musical collaborators. Mr. Dobson had gained underground fame due to his membership of a grime collective called Boys in the Hood, which featured the members Dirty Goods, Titch's half-brother, Crazy Titch and Delta Force. Amongst his better known work was a single that he released called Sing Along in 2004. And Gully, in which he collaborated with the Sugar Babes Keisha Buchanan.
It's crazy! Mineral connection, yeah! We got the boys in the hood, we got the kids, let's move, 2005!
Growing cold, can't control, emotions overflow. Gotta get up and make that money, no time for waiting, honey. Hands on down, my time now. Liquid, I'll put it down. Gotta make it girly, no time for wait.
Mr. Dobson also produced a mixtape entitled Crazy Times Volume 1 and appeared on the Grind DVD Practice Hours. In 2006, Mr. Dobson had made an appearance as himself alongside many other MCs on Channel 4's show Dubplate Drama.
Hey man, what's all this? No! No one don't wanna hear that! That's bullshit!
The grime MC Crazy Titch had a reputation for violence during his time in the grime scene. Notorious footage exists of a heated argument between Crazy Titch and another famous UK grime artist who is known as Dizzy Rascal. And there is also footage of Crazy Titch allegedly kidnapping a rival and dumping them naked in the countryside. The music videos for Crazy Titch's most popular hits, I Can See You and Sing Along, received heavy airplay on Channel AKA and Channel U. Mr. Dobson and his stepfather Anthony Green were sentenced to life imprisonment for the murder of a 21-year-old Richard Holmes, which had took place in the Chingford Hall estate in Chingford in November of 2005. Possibility for parole was set at a minimum of 30 years, by which time he will be in his 50s. Dirty Goods, who was Crazy Titch's half-brother, was acquitted in the same trial and released a song about its events entitled A Letter to Titch in 2007. The Mac-10 submachine gun used in the murder was found 4 years after the killing. In February 2009, a local drug dealer was sentenced to 7 years imprisonment for its possession. In prison, Mr. Dobson is considered to be a high-profile prisoner and has been able to use prison facilities to record material and hold interviews with the outside media. In 2010, Mr. Dobson released his second mixtape, a sequel to the 2005 Crazy Times, with material having been recorded whilst incarcerated. In 2017, Mr. Dobson appeared on the interlude on Stormzy's album Gang Signs and Prayer, talking to Stormzy over the phone.
Yo,
gang.
yes my brother.
You still don't sound sure.
No, I'm in the booth right now. I'm in there right now.
Alright, let's start it.
In 2020, a lyric video was produced titled Voldemort, which included new audio from Crazy Titch. It was uploaded to YouTube to celebrate Titch's birthday in 2020.
Care not if a man writes hard, man best know that I'm raw. These rappers are just bike arms. What's a man talking for? You can have heart, it's when you...
On the 22nd of June 2020, a YouTube channel called Justice for Titch uploaded a video in which Crazy Titch, also known as Carl Dobson, explains briefly details which have led him to be incarcerated, and why he feels of why he was wrongly convicted for the crime of murder. Mr. Dobson also asks for anyone who truly believes in him to go and visit his petition page and sign it. As of today, that petition has 14,000 signatures.
Rubbish solicitor. I think rubbish is a polite way to say, do you know, like that, because there was things I was asking that wasn't happening that could have easily proved my innocence or even disproved some lies that was being told in court.
The petition was started by Lisa Stepanovic, and it is a petition to be sent to the Criminal Cases Review Commission. On the petition, it says, "Everyone deserves a fair trial. Justice for Carl Dobson, aka Crazy Titch." The hashtag Justice for Titch campaign is determined that Carl Dobson, aka Crazy Titch, gets justice that has so far been denied to him in the criminal justice system. In 2005, Crazy Titch was a 22-year-old with an exciting future ahead of him. As a pioneer of the grime scene, together with his contemporaries Wiley, Dizzy Rascal and Kano, they were influencing hundreds of thousands of young people across the UK. Their passionate lyric voiced the lived experiences of working class kids while shining a light on our underrepresented communities. Every deprived housing estate was influenced by grime music. It challenged the powers that be and offered a way out. Within months of his career really taking off, Crazy Titch, aka Carl Dobson, was charged with the murder of Richard Holmes in Chingford. Mr. Dobson stood trial in 2006 and was convicted. We believe that the conviction came about because of the combination of injustices. Some of the injustices that Mr. Dobson and his supporters feel that happened are as follows. Character assassination, due to the moral panic over the genre of urban music in the UK at the time. The joint enterprise law, which often convicts individuals for crimes they have not committed, and it is disproportionately young black men who suffer from the joint enterprise law. Anonymous witness testimonies, which deny individuals the right to know their accusers. The police failings, in which the investigation and the handling of witnesses was not done so correctly. The inherent unreliability of eyewitness evidence. The effect of institutional classism and racism within our court system. The failings of representation. The previous solicitor firm representing Crazy Titch was shut down by the Law Society whilst preparing his defence. The petition states that the evidence in Mr. Dobson's case is unsafe and must be challenged again. Everyone deserves a fair trial. Some of the facts we know are in the court records. It was agreed at trial that Titch did not fire the fatal shot. A supposed eyewitness failed to pick out Crazy Titch from an identification parade close to the date of the shooting. 6 months later, the same witness attended another parade and picked him out after admitting that they had seen a photograph of Crazy Titch in the Evening Standard naming him as a suspect. Another supposed eyewitness, said to have been standing with the identifying eyewitness claiming to recognise Crazy Titch, was unable to pick him out of an identification parade very shortly after the shooting. Also, another supposed eyewitness who did pick Crazy Titch out from a lineup admitted they had seen him in photographs and in newspapers or had recognised him from music videos. Mr. Dobson and his legal team have been working with the criminal defence firm Commons for the past 18 months to take the case back and present new evidence to the Criminal Case Review Commission. They are seeking to overturn the conviction. Mr. Dobson had applied on 2 separate occasions to have his sentence re-looked over by the Court of Appeals. Lord Justice Keane revealed the outcomes of these applications and said the following: "These are the renewed applications for leave to appeal against conviction. This was after leave having been refused by a single judge. On the 2nd of November 2006 in the Criminal Central Court, before His Honour Judge Barker QC, the Common Sergeant. Both applicants were convicted of murder and were sentenced to life imprisonment. A co-defendant, Mr. Mahorn, was acquitted of murder and indeed of the alternative of manslaughter. The victim, Richard Holmes, was shot and killed at about 12:45 AM on the 4th of November 2005 outside the community centre of Chingford Hall Estate in North East London. Mr. Holmes was shot 3 times. There was expert evidence that one shot to the leg had been fired from a converted MAC-10 submachine gun. 2 further shots, one to the arm and the fatal one to the back, which had passed through his heart, had been fired from a .45 revolver. There was also ballistics evidence of a 3rd firearm having been at the scene. Mr. Green and the co-defendant, Mr. Mahorn, lived on the estate at the same address. Mr. Dobson, however, lived in Stratford, East London. It was not alleged by the Crown at the trial that the fatal shot had been fired by any of the 3 defendants. That shot was said to have been fired by a 4th man who was not on trial. But it was alleged that all 3 defendants were jointly responsible for the killing on the basis of joint enterprise. All 3 were alleged to have been part of a gun-carrying group and were to have known what was likely to happen. Mr. Dobson was said to have a MAC-10 submachine gun and was to have fired the shot into the victim's leg. The Crown's case was that Mr. Green and Mr. Mahorn were present and had participated through encouragement. In an interview, Mr. Dobson did not overtly deny presence at the scene. In a prepared statement, he said that at the time of the alleged offence, he was not in possession of a firearm. Mr. Dobson's statement went on to say, "I would further like to confirm that I adamantly deny pointing a gun into the chest of Richard Holmes or shooting Richard Holmes." At trial, he denied being present and had relied on an alibi. In interviews, both Mr. Green and Mr. Mahorn denied presence at the scene of the shooting at the relevant time. At trial, both said they had been on the estate at times that evening but were not present or participating at any time of the shooting. It will be apparent from what we have said that all 3 defendants gave evidence at trial. Events that evening began with some form of confrontation between Mr. Mahorn and Sabah Shah, both of whom were involved with the music business. Things had developed from there. A group of youths, including Mr. Shah and his friend Richard Holmes, went to Mr. Mahorn's address. There was Southside evidence that proved that Mr. Mahorn had telephoned Mr. Dobson and Mr. Green and that they had travelled to the estate along with others. Later that evening, there was a further confrontation between 2 groups, which ultimately led to the death of Richard Holmes. The prosecution case turned largely on the evidence of 3 eyewitnesses who gave evidence anonymously and from behind screens. They were referred to as A, B and F. We do not propose in this judgment to take their evidence in great detail, since this application is for leave. Their 3 accounts varied. In summary, all 3 named Mr. Dobson, who was known as Crazy Titch, as being present at the shooting and as having the MAC-10 submachine gun. The strength of that identification varied between the 3 of them. Witness F identified Mr. Dobson at an identification parade on the 2nd of February 2006. In his evidence, he described Mr. Dobson as jumping around, excited and shaking a gun. Witness B failed to identify Mr. Dobson at a parade on the 28th of January 2006, but she did so at another subsequent parade. The basis of that identification was challenged. Witness A's evidence was that Mr. Dobson was there at the shooting, but she had failed to pick him out in a video identification parade in November of 2005. As for the other 2 defendants, Witness F said that they were both there. He already knew Mr. Mahorn, and he identified Mr. Green at an identification parade. Witness F described the applicant, Mr. Green, as saying to Mr. Dobson about another man, "He's okay." That man was allowed to walk away. Witness A identified Mr. Green as having been with Dobson at the time of the shooting. She was firm about that under cross-examination and said that she was not mistaken. Her evidence was that she did not see Mr. Mahorn there, but she thought that he would have been there. Witness B said that Mr. Mahorn was there, but that Green was not. There was, however, evidence that she had named Green on the night of the shooting as being present. The Crown also successfully applied to use evidence of Mr. Dobson and Mr. Green's previous convictions to show that this was not the first time that they were involved in gun crime. The judge unanimously convicted the applicants, Mr. Dobson and Mr. Green, and unanimously acquitted Mr. Mahorn. Mr. Dobson and Mr. Green now contend that the verdicts in their cases were perverse as being inconsistent with the acquittal of Mr. Mahorn. In addition, and indeed connected with that first point, they both argue that the judge was wrong to allow in evidence of their previous convictions, which may go to explain the willingness of the jury to convict the two applicants while acquitting Mr. Mahorn. The appeal court will deal with these issues first before coming to a separate point raised on behalf of Mr. Dobson. It is convenient to take first the issue of admissibility of the previous convictions, as have counsel today. In his ruling, the judge spelled out the basis for the application by the Crowns as follows. Mr. Dobson was convicted of robbery in August the 27th, 1999, whilst using an air pistol with another in a betting shop. He was sentenced to 5 years detention. This, the prosecution say, is relevant to the matter in issue under section 101D of the Criminal Justice Act of 2003, and it shows that the criminal is willing to commit gun crime and is okay with the knowledge of knowing that a gun is being carried by another man. In the case of Mr. Green, he was arrested in May 1994 in possession of a fully loaded semi-automatic handgun, and in the previous 2 days before he was caught with the gun, had held up 2 petrol stations and a store with the handgun and robbed employees. No one saw Mr. Green with a firearm at the community centre when the murder of Mr. Holmes took place, but the prosecution assert that these offences go on to show a willingness to commit gun crime, and whether he would lend himself to gun crime, and also his knowledge of others carrying loaded weapons. It was also revealed that the 3 robberies and firearm offences on part of Mr. Green were committed in Canada. The judge summarised the arguments on behalf of the defence, which were mainly that the convictions did not help on the central issue of identification, and that the prejudicial effect would outweigh the probative value. In his notes, the judge asked 3 questions to himself. Does the history of the conviction establish that the offender is likely to commit the offences of the kind charged? Does that likeliness make it more likely that the defendant committed the offence charged? And is it unjust to rely upon the convictions of the same description or category, and in any event, will the proceedings be unfair if they are omitted? Having posed the 3 questions, the judge continued as follows. The circumstances surrounding the previous convictions of each defendant are different, and I have considered each case in isolation. The points made by counsel have force, and clearly the admission of this evidence against either will have a substantial effect. I bear in mind that these are single convictions, although in the case of Green there were several offences involving the same firearm. Further, in his case, they were 12 years ago. I have considered the other evidence in the case, as well as the Section 101 1D and Section 103 of the Act. In my view, although effectively single convictions, the circumstances demonstrate much force in relation to the offence charged, and the age of Green's case does not diminish the importance. The critical issue is whether either of these defendants would lend themselves to an attack with firearms. The likeliness in each case has been established. It goes to the heart of the case, and it would not be unjust for them to be revealed. The provisions of the Act are satisfied that I grant the application to place these matters before the jury, and I have in mind that a careful direction must be given in the summing up. On behalf of Mr. Dobson, Mr. Trimmer QC emphasises that his client's previous convictions was allowed in under Section 101D, which requires it to be relevant to the important matter in issue between the defendant and the prosecution. He acknowledges that the Section 103 renders the issue of whether the defendant has a likeliness to commit the offences of the kind of which he is charged, and this is a matter in issue between the defence and the Crown, except where having such likeliness makes it no more likely that he is guilty. But it is submitted that there was no more important matter in issue to which any such likeliness was relevant. The only important issue, it is said, was whether Mr. Dobson was correctly identified, and his previous conviction could not assist on that. The issue at trial, submits Mr. Trimmer, was whether Mr. Dobson or Mr. Green would lend themselves to an attack with firearms. The only important issue was identity. It is said that the law still retains identity as a special case, despite the Criminal Justice Act of 2003. Something akin to the signature or striking similarity about the previous offences needs to exist before such an offence or offences can be seen relevant to the issues of identity. That was not the situation in the present case. In addition, Mr. Trimmer challenges whether the previous conviction of his client was capable of establishing the likeliness to commit an offence of the kind his client was being charged with, namely murder. Mr. Dobson stresses that the past conviction was for a robbery involving an air pistol. It had happened 5 years ago when Mr. Dobson was still a youth. It was a single offence committed for the purpose of gain. Certainly it was not strikingly similar. Finally, on behalf of Mr. Dobson on this topic, it is contended that it is unjust to admit this evidence because of the prejudice that it involved, and the judge failed to give the jury an adequate direction as to its relevance. The judge should have told the jury to exercise great care in how they use this bad character evidence. It should have been tied to the issue of identity. The decision of this court in Turnbull on identification requires the judge to identify what evidence may support the identification of the defendant. That was not done so by the judge here. On behalf of the applicant Mr. Green, Mr. Borelli QC makes similar points on this ground. While adopting what has already been submitted on behalf of Mr. Dobson, Mr. Borelli also emphasises the argument that the likeliness is of no relevance when the defence is one of the alibi and the central issue is the one of identification and the correctness of that identification. It could, it is said, only be relevant if the jury had first been sure that the applicant was present at the scene. While he does not go as so far as to say the previous convictions can never be used to support an identification, Mr. Borelli contends that, in the present case, there were two separate issues in respect of the applicants. First, their presence at the scene, which was denied, and secondly, the participation of the killing if they were present. The likeliness, it is submitted, could only go to the second of those, namely in participation, not in the presence. Furthermore, it is said that the Crown did not seek to have this evidence admitted at trial on the issue of presence at the scene. We turn to consider these arguments. The trial judge posed for himself 3 questions suggested by Rose LJ in Hansen at paragraph 15. When the Crown seeks the admission of such evidence on the grounds of propensity. We have quoted these questions earlier in this judgment and do not need to repeat them. The first of them deals with the issue of whether the propensity of the relevant kind exists. In Hansen, the court made it clear that no minimum number of previous convictions is required to demonstrate a propensity. It very much depends on the nature of the previous conviction, its age, and the rest of the factual circumstances. See paragraph 9 in that case. That same paragraph made it clear that there does not have to be, in the words of earlier authorities, a striking similarity. The number of previous convictions will often be relevant if there is only one considerable iniquity without the special distinctive features, and without such offences in the interim, then it may not be capable of establishing such a propensity, in which there was a single firearms offence 20 years earlier. What was also made clear in Hansen at paragraph 15 is that this court will be slow to interfere with a judge's ruling on the admissibility of bad character evidence if the judge has directed himself or herself correctly. It is only if his judgment as to the capacity of the prior events to establish propensity is plainly wrong, or his discretion has been exercised unreasonably, in the Wensbury sense, that this court will interfere. We agree that this is the approach which should be adopted in the court in cases of this kind. On those principles, it seems to us that the judge here was entitled to conclude that the previous convictions in this case and both the applicants were such as to show the propensity to commit gun crime, whether it be a principal or secondary party. In respect of Mr. Dobson, his was a relatively recent conviction involving firearms for criminal purposes. Even though it is only a single conviction, it could, in our view, suffice. In the case of Mr. Green, his convictions for firearm offences and robbery were earlier in time, 1994, but they were several in number and demonstrated a willingness to carry and use firearms for criminal purposes, if only to threaten. One of the offences involved a loaded firearm. The only purpose of having ammunition in the gun could have been for the possibility that it might have to be used. In both their cases, the past offences, as we have indicated, they both involved the use of firearms. If there was such propensity as the judge found, was it relevant to an important matter in an issue between the defence and the Crown? There was here no dispute that Richard Holmes was shot, and indeed shot by 2 different weapons, and that there were others accompanying the gunman who fired the fatal shots. What was in issue was whether these 2 applicants were the men, or some of the men, who were there and were participating in a way alleged in the murder. There was an important matter in issue. We do not accept that the previous convictions showing a particular propensity cannot be relevant to showing that the defendant was the person who committed the crime charged, merely because identity is put in the issue and the alibi raised. Merely because identity is put in issue and an alibi raised, it does not render propensity irrelevant. It will not by itself be enough to establish the identity, but it may often be capable of supporting the credibility and reliability of other evidence of identification. The point as a matter of principle may be more readily appreciated by postulating more extreme circumstances, as where someone accused of sexual assault of a woman in a street pleads that it is not him and provides an alibi. She identifies him as best she can. Would not evidence that he had several recent convictions for similar assaults be admissible to show that it was him on the occasion now charged, and to support the identification evidence by the victim? We are in the view it would be relevant and therefore admissible, subject of course to the judge's usual discretion. We have taken there what may be a more extreme example, but we do so only in order to make the point more obvious. We do not accept Mr. Trimmer's point about the need for striking similarity in the cases where the main issue is identification. Not only is paragraph 9 of Hansen, which was quoted earlier, contrary to that, but the correct test is now to be found in the provisions of the 2003 Act, and in particular for the present purposes of section 101 1D. Is it relevant to an important matter in an issue between the defendant and the prosecution? As Mr. Borelli acknowledged, bad character in a sense of previous convictions can, if they demonstrate in a particular propensity, be relevant in the issue of identity, which was crucial in the present case. We entirely accept that the matter of degree whether the propensity is established and whether the propensity is relevant. We entirely accept that it is a matter of degree whether the propensity is established or whether the propensity is relevant, but striking similarity is not the test. This can be appreciated from the decision of this court in R vs Eastlake 2007 EWCA Criminal 603. That was a case in which two male teenagers had been attacked by two males who then ran off. The appellants denied that they were the assailants. They relied on defense of an alibi. They asserted that the identifications of them by witnesses were mistaken. Evidence of previous convictions for assault was allowed to go before the jury under section 101 1D and section 103, and in the event both defendants were convicted. On the appeal, it was argued that since the defense was an alibi, the previous convictions were irrelevant. Such evidence, it was said, did not make it more likely that the appellants were present at the scene. The argument was rejected. The court said this: "We do not accept this submission. The jury had to decide whether the two appellants were the two young men who committed the offence. The evidence of bad character was capable of establishing that there was a propensity to commit the offence of street violence and to do so together. The evidence was capable of lending support to the conclusion which the Crown invited the jury to reach, namely that the two appellants were correctly identified as those who committed the attack. This is so even though there is no dispute in the trial that those who committed it, whoever they were, acted as aggressors. We agree with that conclusion for the reasons which we have already indicated. Such evidence may go to show that the witness or witnesses identifying a defendant as present or participating is correct in doing so." Mr. Trimmer, on behalf of Mr. Dobson, sought to distinguish Eastlake on the basis that it was a case of striking similarity. We cannot agree with that. The previous offences which were there were simply ones of street violence. It is true that in one instance the two accused had in the past acted together, but no emphasis had been placed by the trial judge on that particular fact. R vs Purcell 2007 EWCA Crim 2604 is another instance where previous convictions were held to have been properly admitted to support an identification and to rebut a defence of an alibi. Implicit in what we have just said is that we reject Mr. Borelli's argument that the evidence of propensity was only relevant in the present case of the participation of the killing, as opposed to the presence. Just in Eastlake, the propensity in question was capable of supporting the identification of the applicants, as being present and participating in the offence. Indeed, it seems to us somewhat artificial in the present case to separate those two matters of present and participation. What the evidence of propensity was capable of doing was supporting the eyewitnesses' evidence of identification. In short, that what they said they had seen was correct. In other words, had they identified the right people? We can see no merit in the argument that the Crown only sought the admission of this evidence on the issue of participation and not on the presence. This is far too narrow of a reading of the judge's ruling. The judge said that this evidence of character goes to the heart of the case. Patently by that, he meant whether the two applicants were present and whether they were involved in the offence of killing. So far as the exercise of his discretion on the justness or the otherwise of admitting these convictions is concerned, we can see no basis for saying that the judge's decision fell outside the range of decisions properly open to him on the evidence. It was not Wensbury unreasonable. He had directed himself in accordance with the proper principles. As to his decisions to the jury, the judge gave the requisitive, careful directions about the previous convictions along the lines indicated in Hanson and Edwards, 2005, EWCA Crim 1813. Amongst other things, he emphasised that by themselves, previous convictions could not establish guilt. He also made it clear that the jury could not convict wholly or even mainly on the strength of those previous convictions. In our view, he did not need to go no further than he did. Given our conclusion on the relevance on the previous convictions to both the presence and the participation, no specific direction about the relevance of those convictions to the defence of alibi was required. The judge gave the normal direction about the Crown having to disprove the alibi, and indeed repeated it a second time in the course of his summing up. It seems to us that it must have been obvious to the jury that his directions about the possible relevance of previous convictions were relevant to the issue of identity. We say that because it was a central issue in the case. It follows that we can see no proper basis for an appeal on this first and indeed main ground which is put forward on behalf of each of the applicants, Mr. Dobson and Mr. Green. Connected with that, but also said to be an independent ground of appeal on its own right, is the issue with the inconsistent verdicts. It is submitted on behalf of both applicants that the convictions of these applicants is so inconsistent with the acquittal of Mr. Mahorn as to render them unsafe. As a matter of oral submissions, that is the point which has been particularly emphasised by Mr. Borelli, but we take it on board in respect of both of these applications. It is submitted that the cases at trial against Mr. Mahorn and Mr. Green are inextricably linked. We have been taken in some detail through the evidence of the three main eyewitnesses. It is said that to have convicted Mr. Green but acquitted Mr. Mahorn was perverse. As we have indicated already, this overlaps to a degree the other ground, the admission of the previous convictions, in that it is said that the admission of Mr. Green's previous convictions must have been what made the difference, since Mr. Mahorn had none that were put before the jury. The same in effect is said on behalf of Mr. Dobson. In dealing with this as a specific ground, we remind ourselves of the well-established approach as a matter of law to the contention that verdicts are inconsistent and unsafe as a consequence. The legal principles apply whether one is talking about different verdicts on counts faced by the same defendant or different verdicts in respect to two or more defendants. The essential principle is that it is necessary for the appellant to establish that there is a logical inconsistency in the verdicts, in the sense that no reasonable jury, applying their minds to the facts, could have reached those verdicts. It is not enough that it seems surprising that the jury returned the verdicts that they did, or that the appeal court itself might not have returned such a combination of verdicts, had it been sitting as a jury. If there is a possible legitimate chain of reasoning which could explain the apparent inconsistency, this court will not interfere. It is open to a jury to believe a single witness on part or all of her or his evidence, but not accept another part. Those are the established principles. The present case concerned an incident which is in a critical phase, which in its critical phase was relatively brief and fast moving. It took place at night time. It seems there was a considerable number of people around. It is acknowledged by the advice of appeal for Mr. Green that there was a deal of inconsistency in the evidence given by the three main eyewitnesses. Indeed, this is prayed in aid, of course, of the submissions on his behalf. All of that is true. Perhaps, unsurprisingly, and certainly not unusually, the eyewitnesses' accounts of events differed in certain respects from each other. The jury, for its part, had to access the credibility of each of those witnesses and the reliability of their evidence in the various aspects and in the respect of each of the defendants. They had to evaluate what each of those witnesses said about each of the defendants. The jury then heard each of the defendants give evidence, just as they had to do so with the Crown's witnesses. So here again, the jury had to decide how far they believed each of the defendants. In the light of that complex assemblage of decision about at least 3 Crown eyewitnesses and the 3 accused, the jury then had to decide whether they were sure of guilt, considering each defendant separately. In considering the cases against the 2 applicants, they also had their previous convictions to consider. It was not illegitimate to take those into account. It seems to this court that, in that complicated situation, it is quite impossible to say that no reasonable jury, properly approaching their task, could have reached the combination of verdicts which the jury did. We do not know what they have made of each of the 3 eyewitnesses and the 3 defendants. As the single judge said, they may have found witness A particularly convincing when she said that she saw Mr. Green there at the relevant time, but did not see Mr. Mahon. That indeed was a point made on Mr. Mahon's behalf to the jury by his counsel. All 3 eyewitnesses said that Mr. Dobson was there and with a submachine gun. The evidence in the case was patently complex. That being so, we could see no prospect of a successful appeal on the basis that the verdicts were logically inconsistent and therefore perverse. Finally, there is a point raised on behalf of Mr. Dobson about a reference by the judge to the internet. It was a reference made at the outset of the case. What he said was this: sometimes people like to look up on the internet and try and find out anything they can about the background. What is there does not matter. I am not banning you from looking at the internet, but it is really of no help because what you are doing is deciding this case on the evidence that you hear in this court, which we all hear together. It is argued now by Mr. Dobson that that statement undermines the safety of the conviction. A strong warning should have been given not to seek from the internet information relevant to the case, whereas the words used by the judge implied that it was not forbidden to look at the internet. Mr. Trimmer, on behalf of Mr. Dobson, whose submissions on this were adopted by Mr. Borelli on behalf of Mr. Green, contends that the judge, in effect, implied that the jury had permission to look up matters on the internet. if a juror takes into account any such material, then the principle that the defendant is entitled to see all the material on which the jury decides his case is flouted. In that connection, reliance is placed heavily on R versus Karakaya 2004 to CR APP R5, where that principle is strongly endorsed. Mr. Trimmer has obtained some sample pages from the online encyclopedia Wikipedia. Some of the extracts post-date convictions, but others do not. They refer mainly to Dobson's musical activities, but they also include references to other offences for which he is sentenced for in 1999, along with a robbery about which they knew. Those other offences included handling theft, handling stolen goods, theft, burglary, and criminal damage. There is also a reference to him being on trial for a murder by paying someone to kill the victim. We do not find this argument persuasive. The facts here are a long way from those in Karakaya, where documents downloaded from the internet were found in the jury room and had been introduced there after their retirement. The material in question was patently relevant to the issues in the case. Here, there is not a shred of evidence that any juror sought to obtain or did obtain any such material. The submission is based entirely on the judge's comment to which we have referred. That comment could have been put in stronger terms. In our view, it would have been better had it been put in stronger terms. Nonetheless, in the course of it, the judge made it clear that no jury had to decide the case on the evidence which they heard in court. We have not been provided with transcript of the whole of the judge's remarks to the jury at the start of the case from which this extract have been taken. He came back to that again at the start of his summing up, but as the single judge said, and as Mr. Borelli believes happened, the trial judge has evidently just given the jury the unusual warning, the usual warning about not discussing the case, save in the jury room, and basing their verdicts only on the evidence which was heard. We can see no reason to believe that they did otherwise. In that situation, it seems to us that this ground provides no basis for a potential successful appeal. We have taken these various grounds separately, but looking at them whether separately or together, we can see nothing that cases us to doubt about the safety of these convictions, and nothing which merits the further detailed scrutiny of a full appeal. It follows that both of these applications must be dismissed. Mr. Dobson was in the papers again recently when it was exposed that he was in a sexual relationship with a married prison worker whilst he was incarcerated at HMP Long Lartin. Jody Malins, who worked for a courier firm DHL, bringing supplies to the canteen at HMP Lartin. The police arrested Miss Malins at HMP Long Lartin on suspicion of misconduct in a public office and smuggling contraband. In 2010, the mother of Mr. Dobson's victim, Lynn Holmes, criticised how Mr. Dobson was able to record an album using his PlayStation while he was in his previous jail, HMP Swellside. Because of this, Mr. Dobson was moved from HMP Swellside to HMP Long Lartin, which houses some of Britain's most violent criminals. Thank you for joining us today. What are your opinions on the crimes committed by Mr. Dobson and Mr. Green? Do you believe the sentences were too harsh or not harsh enough? Do you believe that Mr. Dobson, also known as Crazy T, and Anthony Green deserve a retrial, or do you agree with the appeal judge's decision? We will put the link to the petition in the description. Please check it out and let us know what you think in the comments. Thank you for joining us today. If you enjoyed this content, please don't forget to like and share, and if you're new to the channel and you want to see more Street Crime UK content, Please don't forget to subscribe and hit that bell button so you can join us on the next video. Thank you for joining us, and until next time, stay safe.
Hello everyone, welcome to the Street Crime UK YouTube channel. Thank you for joining us. Please don't forget to like, share and subscribe for more content. Today we take a look at one of the most infamous UK criminals to ever exist in the UK criminal underworld. From his early years as a gangster in London to his later career in writing, charity work and acting, along with all the controversies. Mr. David John Courtney was born on the 17th of February 1959 in Bermondsey, London. Born to a normal family with a younger brother, his family nor upbringing had anything to do with a turn to crime, according to Mr. Courtney. In interviews, he has described himself as a born leader and someone who was destined for crime at an early age. He was the funny guy in high school and got along with most people around him, but wasn't afraid to employ violence when he needed to assert dominance or someone was trying to mess with him. Mr. Courtney had been involved in debt collecting and bodyguard work, even minding clubs. In his time as an active criminal, Mr. Courtney has also been shot, stabbed, and has his nose bitten off and sewn back on, and also explained at times that he had to kill to stay alive. However, he was mostly known for the intense web of connections that he had ready to help him with any task, earning him the nickname of the Yellow Pages of the underworld. He was propelled into the public eye and stardom when he organised security at Ronnie Cray's funeral. Arranging the funeral as well as he did made him the enemy of the police and painted a target on his back. A man who was able to organise the most serious organised criminals up and down the UK wasn't something the police were just going to bat an eye at. Newspapers painted him as the heir to the throne and used him as a visual for the face of organised crime in the UK. Overwhelmed, Mr. Courtney attempted to back off and stop the titles from being thrown at him, which is when he wrote his first book, Stop the Ride I Want to Get Off. And without meaning for the situation, he did begin to become more organised in his methods. Instead of bursting into people's apartments to demand money, he had to be quieter and sneakier about it. The police had painted a target on his back and warned anyone that worked with Mr. Courtney that they needed to watch out. Soon after, he was the star of a 3-part observational documentary called Dave Courtney's Underworld, which followed him during a police corruption case. He was eventually found not guilty of the crime, and the documentary shows him celebrating with his friends and family. Mr. Courtney has had an illustrious career outside of crime. With his acting to writing, his acting career consists mostly of television documentaries and his appearances as himself, and he has directed a movie called Hell to Pay, which he also starred in. He had a role in the 1990 movie The Craze. It has also been claimed that Mr. Courtney may have been the inspiration of Vinnie Jones's character in Lock, Stock and Two Smoking Barrels. Mr. Courtney is the author of 6 books, all of them very interesting and entertaining to read, with 4 of them reaching #1 bestsellers. Stop the Ride I Want to Get Off in 1999, Raving Lunacy in 2000, Dodgy Dave's Little Black Book in 2001, The Ride's Back On in 2003, and Fuck the Ride 2005, and Heroes and Villains in 2006. Interestingly enough, the books amassed major success with little to no marketing on the parts of the publishers. Due to certain laws, it could be constructed as glamorising crime to display posters everywhere of the book, which is prohibited. The cover depicts him smoking a cigar, which is also limited in its advertising in the States. In 2002, while he was driving, Mr. Courtney was forced off the road in a suspected gang hit. His car was forced off the road by another vehicle and went somersaulting over the highway at 70 miles an hour. He was left for dead with a broken pelvis, a punctured lung, 4 broken ribs and a broken foot, with bruised kidneys. Mr. Courtney was pulled over by police on October 29, 2007. Because the red BMW that he was in had the illegal vanity license plate reading Bad Boy 1. Officers searched his car and found a singular live bullet in his pocket, along with a number of other prop weapons. He claimed it was all for one of his shows to at-risk youth, but he was still taken into custody. He claimed it was blank ammunition, and he was extremely surprised to learn that in fact it was real. However, he was able to talk himself out of a jail sentence by showing the judge how he had reformed as a criminal, and now worked on convincing young men who are on dangerous paths that the crime doesn't pay, and had a slew of charities writing in as character witnesses. The judge presiding over the case, Judge Ticehurst, ended the sentencing by saying it perhaps undermines your street credibility and your stage performance that you cannot distinguish between a real round and a fake round, but perhaps that's not for me to say. He was given an 18-month sentence and a conditional discharge. Later in 2009, in May, Mr. Courtney reportedly owed £400,000 to creditors, including £250,000 in taxes. After filing for bankruptcy, auditors started searching Mr. Courtney's home, Camelot Castle, for assets, and discovered 3 illegal guns. He claimed they were simply used as props for his charity shows and belonged to his wife, who owned a company called Proper Job. However, this didn't change the fact that some of his weapons were prohibited, and he was still on conditional discharge for the possession of a bullet. He spent time on remand in prison, but was eventually cleared of the charges by a jury. The gun that had been prohibited, a Brocock air cartridge pistol, had been legal just a few years earlier when Mr. Courtney claimed to have come into possession of it, but was banned due to the ease in which it could be modified into a cartridge-firing weapon. On October the 30th, 2011, Dave Courtney pled guilty to attacking his wife, Jenny, in their home. He served his sentence for his attack in Belmarsh Prison. In 2013, tragedy struck Dave Courtney and his wife Jenny Courtney. Mr. Courtney's stepson, Jensen Pinto, 23, was shot at point-blank range whilst he had been talking on the phone outside of his girlfriend's house. It was a suspected revenge hit over a drug feud that had left the whole family grieving, including his 2 younger sisters. Things hadn't been smooth for the Pinto Courtney family in the upcoming months to Jensen's murder, which led to Dave Courtney being a suspect in the murder. Mr. Jensen was a drug dealer and had started lashing out repeatedly and flying into rages after taking steroids. Mr. Jensen and Mr. Courtney had even gotten into fistfights, but eventually resolved their issues with one another. In a show of restraint, Mr. Courtney publicly begged anyone seeking vigilante justice to let police find out who did it. Dozens of gangsters from Sheffield, Cardiff and Liverpool offered to help him find who did it, but he graciously turned them down, saying, "I don't want to carry on the cycle of violence." He recognised that the situation at hand could lead to a full-on gang war in the area, which the police were readying for with bated breath. 2 men were eventually convicted of the murder of Jensen Courtney. One was Robert Bleach, who had been the getaway driver, and the second was David Pinto, Jensen Courtney's uncle. They were given lifelong sentences and told to serve them with a minimum term of 31 years before being considered eligible for parole. There are some inconsistencies. Numerous questions and concerns have been raised over the years with regard to the authenticity of Mr. Courtney's life story. One of the largest inconsistencies lied with the relationship with the Krays. Courtney claimed to have worked with them in their heyday, but if that were true, he would have been working with them as a 9-year-old or younger. Frankie Fraser, and a former member of the Richardson gang, had also accused Courtney of embellishing and fabricating his illustrious criminal career and position in the underworld. But Mr. Courtney is resoundingly denied overstating his past, and Mr. Courtney explains that what really happened was that Frankie Fraser had held a huge grudge over his wife running off with one of Mr. Courtney's employees, which is what their disagreement had actually stemmed from. Mr. Courtney turned the tables in an interview and claimed that it was Mr. Fraser who in fact was lying about his career, and the 40 or more hits that he claims to have carried out. He also argues that he shouldn't have had to look up to Mr. Fraser for spending 47 years in prison because it means he was clumsy. You only have to read one of Mr. Courtney's books or watch his films or interviews to understand that Mr. Courtney is a man with extremely valuable knowledge and, given the right platform, could change the life of many of the troubled youth who might be heading down the wrong path and give them a push in life in the right direction in the UK today. Regardless of personal opinions on Mr. Courtney and his stories from the past, it doesn't change the fact that he's built a successful career and helped change lives. He now works with various charities promoting staying on the right side of the law and using the catchphrase "crime doesn't pay." He claims that by sharing his stories he's not attempting to make the world of crime sound appealing. He says, "I'm not trying to glamorise crime, I'm trying to glamorise Dave." Truly, this man is deserving of the OBEs he's given himself, which stands for one big ego. Thanks for joining us today. If you enjoyed the video, don't forget to give it a like and a share, and leave any thoughts or suggestions you have in the comments section. We love to read through them all. And if you're new but enjoy UK true crime content, then subscribe to see when our newest video releases. And as always, stay safe.
Hello everyone, welcome to the Street Crime UK YouTube channel. Thank you for joining us. Please like, share and subscribe for more exciting content. Today, we'll be looking into a criminal who doubled up as a DJ in a club. Mr. Lee Harrison, better known by his moniker,
Hooligan X. Mr. Lee Harrison was born on the 8th of March 1966. He was of mixed race. His mother was of a Burmese Portuguese origin, and his father, Mr. Tom Harrison, is by his own admission an old villain who has spent much of his life cycling in and out of jail, including a 30-month sentence for conspiracy to supply drugs from Pakistan in the early 80s, but more about the drugs later. Mr. Harrison grew up in the North Ormsby area of the town, which now has the enviable record of being one of the cheapest places to buy a house in the UK. During Mr. Harrison's childhood, it was a solid working class neighbourhood where everybody knew everyone, where doors were left unlocked and children would play football or ride their bikes in the streets. Mr. Harrison was an excellent junior boxer. He was known for his looks and didn't like getting hit in the face. Being handy with his fists came in useful a few years later when he got involved in football hooliganism. The Middlesboro front line followed their beloved team around the country, fighting pitched battles against rival fans. He said, "We would get guys from all the nearby estates," says Mr. Paul Slater, who was a member of the front line. It wasn't about the violence, it was about gaining respect for our hometown. And Mr. Harrison loved it. He loved the attention. It was those bloody Saturday afternoons that inspired his MC name, Hooligan X. It was around this time that Mr. Harrison drew a close bond with Mr. Lee Duffy, a former boxer, bouncer, and gangster who was known as one of the most feared men on the Teesside estate in the 80s. For more about Lee Duffy, do check out his video on our channel. Mr. Harrison left school with no qualifications and immediately started helping his dad out in the copying game. At one stage it was mainly counterfeit clothing. They used to get bundles of gear, tracksuits and trainers, and that was the fashion then, and they'd sell it all over the northeast. But they also had a sideline in fake Rolex watches and perfumes. They would get the bottles in Romania, the essence from France, and the boxes were made in Birmingham. It was all done professionally. It would cost you about £2 to make a bottle of Coco Chanel. It was a life of crime that paid for the flash clothes, fast cars and fancy foreign trips, but music was always Mr. Harrison's passion. As a 6-year-old, when they were invited to weddings, he'd be on the dance floor and he was unbelievable. Mr. Harrison's love of music was inherited from his dad. Mr. Tom Harrison ran the doors at the Speakeasy, a nightclub that later became the Havana, and had a huge record collection. The pair listened to reggae, particularly Bob Marley at the time. Mr. Harrison spent summers working in Spanish resorts. He started by handing out flyers for nightclubs, but graduated to working as a DJ. People just wanted to dance their tits off all night, says Mr. Allen, who accompanied Lee on one of the trips and was later to become a DJ at the Havana. They were just lost in the music. It was in places like Ibiza and Tenerife that many British clubbers first experimented with ecstasy and later started taking it back to the UK. During his time in Spain, Mr. Harrison mixed with DJs who were later to become some of the biggest names in the British club scene. In Middlesboro, a local club owner put him in charge of entertainment at the Havana and later the Arena nightclub in town. The 1990s proved to be boom times. The money was rolling in, but it all came to a shocking end for Lee in 2001. It was called the Second Summer of Love. 1989, a new genre of music is sweeping through nightclubs across Britain. It's reached the gritty northern English town of Middlesbrough, and the Havana nightclub is packed and bouncing. The synthesized beat produced by the Roland TB-303 bassline machine is vibrating through the walls, and clubbers are dazzled and blinded by strobe lights, disco balls and smoke machines. The Havana is like a furnace inside. Condensation is dripping from the ceiling, sweat is pouring down the clubbers' faces, but they're completely entranced by the music. The scene is inspired by house music, a genre of electronic dance music pioneered in the US city of Chicago in the early 1980s, but it's also being fueled by the appearance of a little white pill, ecstasy. It's illegal, but over the years it's been blamed for many deaths. Its use has sparked a moral panic across Britain at the time. Headlines appear in the newspapers warning about the evils of ecstasy, but many of the clubbers at the Havana don't care. It's their drug of choice, creating a feeling of euphoria that lasts for hours. Dancing beside the DJ box is MC Hooligan X, Mr. Lee Harrison. He is a devilishly good looking guy, and it's his job to whip up the crowd. He revels in it. He's like a prince who has found his people. You chill, I chill, on a pill, we all chill on a pill. He raps into the microphone and the crowd lap it up like a collective communion. They respond with shrill blasts from their whistles. Their ears are ringing, but they can't get enough of it. Even when the police or the fire brigade raid the club, old Bill, everyone shouts, and Hooligan X starts rapping. It's a coded warning. The drug dealers peddling ecstasy scurry into the shadows and stash their supplies. The fire exit pops open, and Mr. Harrison was a face everyone knew around Middlesboro. He was often seen bombing around town in his open-top convertible with the music blaring. Lee would get where the wind doesn't get, but in a lovely cheeky way, says his childhood friend Mr. Alan Appleton. He was a good-looking lad and could get any woman he wanted. You would see photographs of him with Mike Tyson and you would just snigger. But for all of Lee's charm, there was a violent side to him. Someone who knew him said that he had pulled a gun on him during an argument. A friend recalls Mr. Harrison spiking his drink with hallucinogenic drugs for a laugh. There's always been a dark, sinister side to the nightlife. Everybody misses that time, says one former regular at the club. It was a feeling of being all loved up, but it became a very intimidating scene. This was the dangerous world that Mr. Lee Harrison had now moved in all of his life, but it would catch up to him more than 25 years later. Mr. Harrison was soon to be embroiled in a sea of crimes and controversies, and is even accused of orchestrating a sinister and violent murder. It's been described as one of Middlesbro's most notorious murders. A 41-year-old market trader, Kalvant Singh, was found dead after falling from the window of a house in the town, but it soon became clear that it was no accident, and he had been pushed out of the window. A local news website said that Mr. Singh had found himself in the middle of a so-called turf war concerning the supply, distribution and sale of drugs to prostitutes in Teesside and Middlesbrough. 4 men were wanted in connection with the murder. One of them was Mr. Harrison. He went on the run to Scotland, South Africa, Amsterdam and finally to Jamaica. His family used to take holidays on the island and had friends there. After a year, Mr. Harrison was arrested and extradited back to the UK. In 2004, he received a 9-year jail sentence after pleading guilty to manslaughter, grievous bodily harm and wounding. His father was also imprisoned for several years for trying to silence witnesses. Mr. Lee was freed from jail in 2009 and settled in Portsmouth. He was married to Tamara, whom he had met while on the run in Jamaica. He told friends that he was going to turn over a new leaf. He wanted to go straight, and he found work as an electrical cable fitter. But things didn't work out as he planned, and in 2015, Mr. Harrison's marriage was falling apart. A few days before Christmas, he boarded a flight to Lebanon. He said he was going to spend the holiday with a Lebanese friend in the Bekaa Valley. It was a journey that ultimately cost him his life. Some 3,700 kilometers from Middlesbrough lies Lebanon's magnificent Bekaa Valley. Running for 121 kilometers, it's flanked by snow-capped mountains on one side and war-torn Syria in the east. The Bekaa has long been known as the country's breadbasket, famed for its Roman ruins and world-class wineries. But it's also a wild frontier, a place where the police often fear to tread. There are thousands of outstanding arrest warrants that the Lebanese call them the Faran, the fugitives. And if you know the right people in the Bekaa, you can get away with almost anything. Crime flourishes in this impoverished region. Smuggling over treacherous mountain paths is a rite of passage for many. One of the valley towns is infamous for being a hub for stolen cars, but it's what you find at the feet of Mount Lebanon's slopes that brings us here. Acres and acres of lush green cannabis plants, producing some of the finest resin in the world. Mr. Harrison came to the Bekaa to stay at the home of a man called Adonis Al-Mazri. Mr. Al-Mazri has a brown gingery beard, but if you looked closely you'd see it was covering scars. As a teenager in the 1980s, he was caught up in one of the bloody feuds that frequently erupt among the Bekaa's sprawling families, which control the valley. Mr. Al-Mazri was shot in the face. He's had dozens of skin graft operations to try and repair the damage done to his jaw. A relative says that the traumatic event warped his life, and ever since he's relied on drink and drugs to numb the pain and combat depression. They say he's a volatile character prone to mood swings.
Mr. Al-Masri and Mr. Harrison knew each other from the time in the United Kingdom. On one occasion, Mr. Al-Masri was introduced by Mr. Harrison to his father at a birthday party held at an Italian restaurant in London's West End. Mr. Tom Harrison's first impression was that Mr. Al-Masri seemed alright. It was a view shared by others. But during the UK inquest after Mr. Harrison's death, Mr. Harrison's half-brother, Mr. Gerald Copeman, was quoted as saying that Mr. Al-Masri claimed to have killed the man who had shot him in the face. Several friends also recall Mr. Al-Masri bragged to the ties of Hezbollah, the Lebanese Shia organisation whose military wing is designated a terrorist organisation by the UK and many other countries across the globe. Perhaps most bizarrely of all, Mr. Al-Masri boasted of having helped free the British hostage Mr. Terry Waite, who was held in Lebanon during the Civil War in the 1980s. Whatever the truth, Mr. Al-Masri is one of the most prominent and powerful families in Bekaa Valley. His great-grandfather, Mr. Mohim Qasim Al-Masri, was hailed as a courageous freedom fighter against Lebanon's former Ottoman and French occupiers. Mr. Al-Masri's grandfather, Mr. Naif Al-Masri, was a member of the Lebanese parliament from 1960 to 1972. Remember that name, we'll be returning to him a bit later on. Mr. Al-Masri himself has political ties. He organised gatherings at his home for one of the main Lebanese political parties during the recent election. He posted pictures of himself on social media with top politicians. Anybody seeing these pictures would be left with the impression that Mr. Al-Masri is a man with powerful friends. Like almost everyone else in the Bekaa, Mr. Al-Masri had access to guns. It's a way of life up in the valley. There was a wide array of submachine guns and rocket launchers, as well as an innumerable number of pistols and grenades. On the right hand side of the balcony, there was also a pile said to be about 5 high and 6 feet wide of brown coloured powder. Well, you guessed it right, it was cannabis, that drug that Mr. Adonis and Mr. Lee mainly peddled to earn a living. Mr. Lee was not in Bekaa to celebrate Christmas after all. According to his family, he was in fact in Lebanon to do a drug deal. 4 months later, it would all go tragically wrong. Of all the illicit activity for which the Bekaa is renowned, nothing surpasses its drug production. The UN ranks Lebanon as the world's 3rd largest producer of hashish, a psychoactive substance smoked or ingested, made from cannabis resin. Lebanon is also a significant producer of phenethylene, an amphetamine-like pill, better known as Captagon, and a transit hub for cocaine and heroin. It's hashish above all, that's what's made Lebanon's name in the international drug world. In July 2018, the consulting firm McKinsey proposed legalizing its cultivation and sale for medicinal use in order to invigorate Lebanon's stagnant economy. The economy minister said it would amount to $1 billion industry, praising the quality of local produce as one of the best in the world. In the freewheeling late 60s, at the time of Woodstock, the Summer of Love and the radical counterculture, Lebanese hash was in vogue. Pilgrims would take it across the hippie trail by minibus from Europe to Lebanon, seeking enlightenment at the source, before journeying on to Afghanistan, India and beyond. The Brotherhood of Eternal Love, a zany Californian group of surfers, stoners and drug dealers dubbed the Hippie Mafia, was said by the US Drug Enforcement Administration to have imported almost 2 tons of Lebanese hash to the US by the early 70s. Other notable buyers included the car heiress Miss Christina von Opel, arrested in St. Tropez in 1977 with 1.6 tons of Lebanese hash, and the former Welsh smuggler and spy turned author Mr. Howard Marks, who arranged the transportation of hundreds of kilos of the drug using Lebanese diplomats, according to Mr. Jonathan Marshall in his book The Lebanese Connection, Corruption, Civil War and the International Drug Traffic. The Lebanese Civil War, which took place between 1975 and 1990, was a great boon to the industry, with the collapse of state authority and the rise of rapacious militias with few scruples about making money by any means. The area of farmland used for the hash cultivation grew to 4 times its pre-war size, estimated at 10,000 hectares, roughly the size of 10,000 rugby pitches. Not just hash, but heroin too, began to be produced in large quantities there, and the warlords who controlled the supply lines and seaports amassed vast fortunes. After the war, the heroin was mostly stamped out, and the hash farmland much reduced, though far from eradicated. Recent years have seen the introduction of captagon, a stimulant reportedly consumed by fighters in the Syrian conflict, as well as recreational users in the Gulf Arab states. Captagon was originally the name of a pharmaceutical drug used to treat attention deficit hyperactivity disorder and narcolepsy, but it was banned in most countries during the 1980s because of its addictive properties. Now, captagon is reportedly the most popular drug consumed in the Gulf countries and Saudi Arabia, while these deeply conservative Islamic states take a strict zero-tolerance approach towards all intoxicants. Users appear to be drawn to captagon in the belief they're taking medication. Throughout these decades, the illegality of the drug trade has been circumvented by official corruption, at times implicating figures in Lebanon's highest offices, and members of the Al-Masri clan have played their own part. Remember Adonis's grandfather, Mr. Naif Al-Masri, the Lebanese MP? Well, in 1970 a plane was seized in Crete carrying more than half a ton of hashish, worth more than $1 million at the time. According to the book The Secret War Against Dope by Mr. Andrew Tully, the plane had taken off from a freshly constructed airstrip on Mr. Naif's estate in the Bekaa. It appears then that Mr. Adonis was no stranger to the world of drugs. A relative was quoted at Mr. Harrison's inquest as saying that the family owns a cannabis farm. As for Mr. Harrison, he was approaching 50 years old and felt he was running out of time to make his mark. He told Mr. Gerald that his deal was going to be the big one and it was do or die this time. Mr. Harrison's plan for Lebanon was straightforward enough. He would fly out there in late 2015 to oversee a drug deal with the help of his host, Mr. Al-Masari. But upon reaching the Bekaa Valley, Mr. Harrison's plan began to quickly unravel, and before he knew it, strange things started to happen to Mr. Harrison. In January 2016, he was abducted at gunpoint and interrogated for several hours by people with American accents. He believed they were working for the CIA. The following month, while applying for a routine extension to his tourist visa, he claimed his passport was taken by the Lebanese authorities on the grounds that he was wanted by Interpol. British police later asserted that he was never in fact wanted by the organisation. These bizarre developments, coupled with an imploding marriage back home, started taking their psychological toll on Mr. Harrison, and he went downhill massively. He had lost a lot of weight and would appear unkempt on video calls and at odds with his reputation for sharp dressing. A family member was quoted at the inquest as saying that Lee had told him that he had a smoke on a few occasions, and that he had taken that as a reference to cannabis. The coroner speculated that if this was the case, it could have further fueled Lee's mood swings. A member of the Al-Masri family claimed that about a month before his death, Mr. Harrison had to be dragged down from a ladder after attempting to hang himself. At other times, friends remember him rambling incoherently about being held by ISIS and the Taliban. He didn't sound like the same Lee that we knew, said one of his friends. Towards the end, the court was told Mr. Harrison grew convinced his host had turned on him, thinking that he was an undercover agent. He mentioned in a phone call, "They're all whispering and talking about me and saying about taking me away and having something done." In his final days, things escalated dramatically. Lee told another half-brother by text message on the 15th of April that his host has had me done in over here. His brother replied, "You need to get out as soon as possible." The next day, Mr. Harrison fled the house, stabbing a gardener in the process, only to be knocked down seconds later by a car in the street. Mr. Harrison told his family that he had briefly gone to hospital. The court heard that after the reported incident, Mr. Harrison was moved to the home of Shahid Habshi in the nearby village of Deir al-Hamar, and Mr. Habshi describes himself as a friend of the Al-Masri family. Mr. Harrison at this time grew fixated with death, asking one friend to look after his kids and telling his father, Mr. Tom Harrison, to have his body and blood checked in the event of his demise. In contrast, Mr. Shahid Habshi said that Lee was happy in his household, eating healthily and bonding with his hosts over food, even teaching them how to make fish soup. On the 20th of April 2016, Mr. Shahid said that he went out to buy some honey at the request of Mr. Harrison. When he came back, he found Mr. Harrison hanging from his front door. The Lebanese authorities later declared it a suicide, though Mr. Harrison's father and half-brother Mr. Gerald insist to this day that he was murdered. In the aftermath of his death, hundreds of mourners gathered at St. John's Church in the heart of Middlesboro to give Mr. Harrison his final send-off on the 20th of May 2016. Pallbearers carried his coffin into the church to the sound of Natural Mystic by Bob Marley. The mourners heard about Mr. Harrison's devotion to his 3 children. Delivering the eulogy, a friend said Mr. Harrison lived an action-packed 50 years. He was streetwise and had a special bond with his dad, wheeling and dealing. That was the family trade. Back in Lebanon, the authorities were investigating a news report in the local Daily Star newspaper on the day that Mr. Harrison died. It said that it was initially believed that he had taken his own life, but it quoted doctors as saying that they didn't believe that he had killed himself. The first medical examiner was inconclusive. He could not determine whether Mr. Harrison had taken his own life or been murdered. He told the news agencies, both UK and Lebanese, that he was not happy about the process, but would not comment any further. 2 other medical examiners later concluded that Mr. Harrison killed himself. A UK pathologist who examined Mr. Harrison's body agreed that it was likely he died from hanging. When his body was returned to Teesside, pathologist Dr. Peter Nigel Cooper examined it, and he mentioned that there were no self-defense injuries which would be consistent with an attack. He added that Mr. Harrison would have been difficult to strangle, as well as other common sense factors, so dismissed the idea of murder. For those reasons, ligature strangulation was unlikely and hanging was likely, added the expert. However, Mr. Harrison's dad dismissed the idea of suicide, adding, "Of course I believe he was going to be murdered. I know my son was murdered. I believe it. I know my son and there's no way he would take his own life. He lived for his children, he had so much to live for, and he was a happy-go-lucky guy." Mr. Adonis Al-Masari questioned by Lebanese police and denied having any business ties with Mr. Harrison. The BBC repeatedly contacted the Lebanese businessman, who unsurprisingly has no criminal record, for comment, but he didn't respond to the requests. In the UK, the inquest into Mr. Harrison's death returned an open verdict in December 2017. The coroner said, "There is no evidence Mr. Harrison was unlawfully killed, but I can't be certain that he intended to take his own life." She also said that it was the opinion of the British police that it was highly likely that Mr. Harrison was involved in some organised criminality whilst in Lebanon. During the inquest, half-brother Mr. Gerald said in a statement, "Lee is like a 10% man. He would introduce people to people. He told me this. I think Adonis did the introduction to the main supplier or cultivator, the main source." So why did things end so badly? Well, the inquest heard that a relative of Mr. Adonis Al-Masri told the British police that Mr. Adonis had in fact stolen £150,000 from Mr. Harrison, causing the drug deal to collapse. Mr. Gerald also strongly believed that Mr. Harrison was the surety, the living surety, and because it never happened, they made an example of him. The reality is we'll probably never know what exactly happened in these final days. But Mr. Lee's father is in little doubt. He says, "I know my son and there is no way he would take his own life. He had too much to live for and he loved his children." We still do not know for sure whether the drug deal was for cannabis or Captagon or indeed something else, but Mr. Tom Harrison believed the drug deal was for MDMA or ecstasy. Lebanon is not known for producing that specific drug, although seizures of ecstasy are on the increase in the country. The shadowy world of illicit drugs is constantly evolving and throwing up surprises. And Mr. Lee Harrison had travelled a long way from those early euphoric nights at the Havana club. But in the end, it may have been the ecstasy that killed Hooligan X. A club promoter, Ricky Magowan, who works in Glasgow, was pals with Lee for 30 years. He said that Lee is a big hero up here with a lot of friends. He was a great friend to me and a lot of people up here. We're planning on having our own party up here and we'll be inviting anybody from Middlesboro who wants to join us. I'm going to speak to the family about it before pitting out the arrangements. Tributes were also paid on social media. Miss Amanda Britton said that the world's lost a legend and Borough has lost a legend. Rest in peace, Lee Harrison. Miss Lee Foza said that I cannot believe we lost yet another great lad. He meant a lot to a lot of people, not just in Middlesboro but all around the UK. MC Lee Harrison, I'll raise a glass tonight for you until we meet again. Thank you for the memories from the Borough frontline days to raving and salute. And another Netzian, Mr. Mark Foster said, rest in peace Lee Harrison. A true lifelong friend with so many great memories and one of the top doggy lads. Till we meet again, big man. Posts were also placed on the Borough fan page, Fly Me to the Moon. One poster said, heard the sad news this morning that Lee had died, lived the high life but missed his doggy life. Not a saint but had more friends than enemies. His dad pleaded with him to leave Lebanon after spotting AK-47s and RPGs during a web chat. Mr. Harrison's life saw him rub shoulders with gangland figures like Lee Duffy and his pal Mr. James Rowan, who he met inside the Kirklivington prison. He revealed at the inquest that Mr. Harrison told him ISIS and Hezbollah had threatened him. Mr. Rowan said that he wanted to warn British police but feared the claims were too far-fetched to believe. But in a statement, Mr. Rowan said he did not trust the host who Lee was with. He said that he had previously met one of the hosts and that he told him he was from a powerful family and part of Hezbollah, and that he had access to firearms. And Mr. Tom Harrison claimed his son feared the hosts were going to do him in over suspicions that he was an undercover policeman. Mr. Tom Harrison vowed to fight for his son's inquest to be reopened after Teesside's coroner's court heard that the 50-year-old had been involved in a £150,000 drug deal involving cannabis while staying in Lebanon with a powerful family that boasted links to Hezbollah. However, the truth of the matter is that Lee is the only person who'll ever know what happened. Paying tribute to his son, he said that he'd always tried to encourage him to stay on the straight and narrow, adding, "You could not have met a better lad than my son. He was very loyal to me and he never wanted for anything." Tom Harrison has attacked the investigation by Lebanese police, accusing them of making a number of alarming errors that led them to reaching a verdict of suicide. He is also questioned by British officials of not helped him access his son's preliminary autopsy reports, his passport and phone, raising suspicions of a cover-up. He added, even the dates which these family members are all saying was the day Lee was killed is 3 days before the actual day he died. How is that possible? And why do they need 3 doctors to examine the body, he said. There's too much that is just bungled in this case. So, was Hooligan X murdered in Lebanon after a CIA blunder led to a criminal gang mistaking him for a spy? Or was he simply a prey to the Class A drugs that had been consumed? Let us know what you think in the comments section, and let us know what you think about Mr. Harrison's death. If you enjoyed the video, drop us a like and subscribe to our channel for more exciting content. And as always, stay safe.